This is Barry Zalma, speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about judicial restraint and why an appeal goes back to the district court on a coverage claim by an injured party. Jacob E. Godlove Sr. and Kyla Kelly, on behalf of themselves and the estate of Jacob Godlove Jr., collectively referred to as the appellants, appealed to the district court's order denying their motion to intervene in an insurance coverage suit. In County Hall Insurance Company versus Mountain View Transportation and many others, the United States Court of Appeals for the Third Circuit on June 16, 2023, dealt with the changed circumstances. Godlove and Kelly, who was pregnant at the time with Godlove Jr., were in a motor vehicle accident with a tractor-trailer owned by Mountain View Transportation and driven by John R. Humes. Godlove and Kelly, on behalf of themselves and the estate, sued Mountain View and Humes in state court for the resulting injuries, including the death of Godlove Jr., which occurred 2 months after the accident. Mountain View's insurer, County Hall Insurance Company, claimed its insurance policy did not cover the accident because Humes was not listed on the relevant schedule of drivers. The letter also informed Mountain View that County Hall would defend the state court tort action under a reservation of rights. County Hall filed a federal court case against Mountain View and Humes seeking a declaration that the policy did not cover the accident. After Mountain View and Humes failed to respond, the clerk of the court entered a default against the County Hall's request. After appellants filed the state court declaratory judgment action, County Hall moved the district court for a default judgment in this federal action. The same day, the appellants moved to intervene in this action and to strike the entry of default. The district court denied the motion to intervene and the motion to strike. During the pendency of the appeal, appellants settled the underlying state court tort suit against Mountain View and Humes, who were represented by counsel under County Hall's reservation of rights. Appellants obtained a $1 million judgment against Mountain View and Humes and an assignment of rights under any insurance policies. Soon after, appellants again sought a declaration in state court that the insurance policy covered the accident, this time standing in the shoes of Mountain View and Humes. That action remained pending when this case was brought to the Third Circuit. When the district court entered its order denying the motion to intervene, appellants were only plaintiffs who had asserted tort claims against the insured. In the district court's words, they were strangers to the insurance contract. That is no longer so because of the assignment. Analyzing the issues, the Third Circuit noted that the appellants now have a judgment against Mountain View and Humes, and they have a purported assignment of rights under Mountain View's insurance policy, and have sued County Hall in state court on that basis. The Third Circuit concluded that since the district court might reach a different conclusion on the motion to intervene in view of the changed circumstances, or the purported assignment of rights might require or permit party substitution of the federal rules of civil procedure, and because no declaratory judgment has been entered, it might be appropriate for the district court to stay this action pending resolution of the state court declaratory relief action. The Third Circuit, therefore, exercised judicial restraint and refused to express any view on the propriety of the stated possibilities. For that reason, the Third Circuit decided to avoid making a decision and allow the district court to evaluate the changed circumstances in the first instance. Consistent with the principle of judicial restraint, the Third Circuit vacated the district court's order and remanded the case back to the district court for further proceedings. In my opinion, when facts change after a ruling by a district court on an insurance coverage issue, it is inappropriate for an appellate court to stomp on the jurisdiction of a trial court. Noting that the changed facts could have resulted in multiple different resolutions, including the intervention, the Third Circuit exercised the required judicial restraint and required the trial court to decide the issues by taking into consideration the changed facts, and were thereby exercising the wisdom that is usually accorded to King Solomon. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. It's also available free to anyone who goes to the videos at rumble.com or at youtube.com. And if you do, I'd appreciate it if you click on the like button or on the thumbs up button at YouTube. And if you found it useful, please tell your friends and colleagues about the blog and the videos and let them subscribe to the blog and videos as well. They're all free. And if you wish further detail, you might consider subscribing to my Locals community or my Substack publications, where you can get detailed insurance law, insurance claims, and insurance fraud videos and other proceedings and articles. Thank you for your attention.